5 seconds to go. Start. The submission of Mr. Jain for the appellants that mere right to maintenance would not ipso facto create any charge on the property, and that for creating legal charge recognizing right of Hindu women to maintenance required execution of a document, device or agreement cannot be countenanced. Her pre-existing right to maintenance, coupled with her settled legal possession of the property, would be sufficient to create a presumption that she had a vestige of right or claim in the property, though no document was executed or specific charge was created in her favor, recognizing her right to maintenance in the property. It may be noted that in the will executed by Hari Narayan ji in favor of Dolal ji, there was no mention of the suit property. What was stated in the will was that whatever movable and immovable property which belonged to Hari Narayan ji would be devolved upon Dolal ji. It was only in the probate proceedings filed by Dolalji in respect of the said will he had shown the suit property in the schedule. It is true that the objections raised by Bhonari Devi against granting of probate in favor of Dolalji were not accepted by the probate court, and the alleged will executed by Hari Narayan ji in favor of Bhonari Devi was also not proved by her in the said proceedings. Nonetheless, in view of her pre-existing right to maintenance from the estate of the HUF of her husband, and in view of her exclusive settled position of the suit property prior to and after the commencement of the Act of 1956, the only conclusion which could be drawn would be that Bhonri Devi had acquired the suit property in lieu of her pre-existing right to maintenance, and that she had held the suit property as the full owner and not limited owner by virtue of section 14(1) of the said Act of 1956. As stated earlier, Hindu women's right to maintenance is a tangible right against the property which flows from the spiritual relationship between the husband and the wife. Such right was recognized and enjoined under the Shastric Hindu law long before the passing of the 1937 and the 1946 Acts, where a Hindu widow is found to be in exclusive settled legal possession of the HUF property. That itself would create a presumption that such property was earmarked for realization of her pre-existing right of maintenance, more particularly when the surviving co-partner did not earmark any alternative property for recognizing her pre-existing right of maintenance. The word possessed by and acquired used in section 14(1) are of the widest amplitude and include the state of owning a property. It is by virtue of section 14(1) of the Act of 1956 that the Hindu Widows Limited Interest gets automatically enlarged into an absolute right when such property is possessed by her, whether acquired before or after the commencement of 1956 Act in lieu of her right to maintenance. Thus, it is clear from the above observations and findings in the case of Munni Devi Supra that this court, after taking into consideration the pre-existing right of Bhonari Devi to maintenance from the estate of the HUF of her husband and her exclusive settled possession over the suit property, concluded that she had acquired the suit property in lieu of her pre-existing right to maintenance, and that she had held the suit property as the full owner and not limited owner by virtue of Section 14(1) of the Succession Act. Stop.